Dear listeners, you are welcome to the course of the Social Labor Relations in the Maritime industry. Discussing management of social labor relations in ship's crew, we have already covered the questions on the origin of the Maritime Labor Convention, its function, mechanisms, and regulations covered by the Title I of the Convention. Today we are learning to the second and the third titles. Conditions of employment are in the center of our attention, and we are going to consider 8 regulations. They are seafarers' employment agreements, wages, hours of work and hours of rest, entitlement to leave, repatriation, seafarers' compensation in the event of ship's loss or foundering, manning levels, career and skills development opportunities. First of all, let's mention that the regulations of seafarers' employment agreement 2.1 are implemented to ensure that seafarers have their fair contracts. It is obtained through a number of terms and conditions of your employment. You are entitled to a fair employment agreement or contract. It must be signed by you and your employer, be easy to understand and legally enforceable. On the employer's side, it can be signed by the shipowner, the shipowner's representative, or another person acting as the shipowner, such as the ship manager or agent or bareboat charterer. The shipowner is responsible for ensuring that your rights under the employment agreement or contract are respected, even if you are also working for another company on the ship. For example, seafarers working as hotel staff on cruise ships. You must receive and keep a signed original of the agreement, a copy of which must also be available on board. Make sure you fully understand your rights and responsibilities. You have the right to seek advice before you sign. Applicable collective bargaining agreements are normally incorporated in the employment agreement. All information on the terms and conditions of employment, including the collective bargaining agreements, must be freely accessible to everyone on board and available for inspection in port. If your employment agreement or collective bargaining agreement is not in English, for ships operating in international waters, an English language version must be available on board. In addition to the employment agreement, you must receive a record of your employment or discharge book. This will help you when seeking another job or making a case for promotion. This record must not include reference to performance or discipline issues. It is simply a document of your service. What must be in your employment agreement? Firstly, your full name, date of birth, age and place of birth, shipowner's name and his address, place where and date when the agreement was signed, position on board, for example, the third engineer, able seaman or cook, amount of your wages and how they are calculated, amount of paid annual leave, conditions for terminating the contract, including notice period for agreements of indefinite length. This must not be less for the shipowner than for the seafarer. For example, you cannot be asked to give 2 months' notice if the shipowner only has to give 1 month. Expiry date. If the contract is for a fixed term, you must entitled to keep when you will be discharged. Port of destination. If the contract is for a specific voyage, you should know how long it will be after your arrival before you will be discharged. Health and social security benefits provided by the shipowner. Details of your entitlement to repatriation. reference to the collective bargaining agreements if applicable. Any other details required by national law. So regulations on wages 2.2 is known to be one of the central parts of the Maritime Labour Convention, as the first aim of seafarers is to earn for decent life. All seafarers must be paid for their services in accordance with your employment agreement or collective bargaining agreement. You have the right to be paid regularly and in full and at least monthly. Your employer must provide you with a monthly account setting out payments due and amounts paid, including wages, additional payments, and the rate of exchange if the currency is different from that set out in the employment agreement. Basic pay or wages means pay for normal hours of work, normally no more than 8 hours per day and not more than 48 hours a week. Basic pay should never be less than the recommended minimum wage. If you are a member of a trade union, your wage will often be negotiated between your employer and your trade union on your behalf. The International Labour Organization sets recommended minimum wage for able seafarer based on a formula that takes into consideration changes in the cost of living and exchange rates against the United States dollar in a range of maritime countries. It is used as a reference by shipowners and trade unions when agreeing wage scales. No seafarers should be paid at a rate below the recommended International Labour Organization minimum. If you are required to work more than your normal hours of work, you should get paid overtime. This should be covered by national law or your collective bargaining agreement, and the rate of pay should be at least 1 1/4 times the basic rate. In some agreements, the basic pay and overtime is consolidated into one sum, in which case the same principles should apply. Overtime records should be kept by the captain and endorsed at least monthly by you. If you have to work on a day that is specified a day of rest or a public holiday, either by national laws or the terms of your collective bargaining agreement, then you should be entitled to overtime. Overtime payment or time off in lieu. It is good practice to keep your own copy of overtime records in case of disagreement. Your employer must ensure that you are able to send all or part of your earnings home. This could be by regular bank transfer or remittance agreed when you sign the contract. Remittances should be sent on time directly to the person or account nominated by you. You shouldn't be expected to pay unreasonable charges for such services. The exchange rate must be at the current market rate or at the official published rate that is not unfavorable to you. Your entitlements. Seafarers on the same ship should be paid equally pay for equal work without discrimination. Seafarers' employment agreements should be available on board, including details of rates of pay. You should be paid in full any outstanding remuneration on termination of engagement. If the ship owner fails to pay any outstanding remuneration without undue delay, contact your union representative or representative of the flag state or port state. There should be a system in place to penalize owners that don't pay their seafarers. Failure to pay wages is a matter that is subject to ship inspection by the flag states and port states and may result in the detention of a ship. No deductions can be made from your pay, including fees for obtaining employment, unless expressly permitted by national law or agreed in a collective bargaining agreement. Any charges that are made, such as for a service provided on board over and above the terms of your agreement, should be fair and responsible. You are free to decide how to spend your wages. The next regulation is 2.3, which is hours of work and hours of rest. It is implemented to ensure that seafarers have regulated hours of work and hours of rest on board. Hours of work and rest are regulated to avoid fatigue and to ensure that the ship is operated safely. Normal working hours are based on an 8-hour day with 1 day of rest per week. How this is applied may vary according to your collective bargaining agreement or employment agreement. The flag state can decide whether to base the limits of maximum hours of work or minimum hours of rest. So, maximum hours of work. You mustn't work more than 14 hours in any 24-hour period. You mustn't work more than 72 hours in any 7-day period. So, minimum hours of rest. You must have at least 10 hours of rest in any 24-hour period. You must have at least 77 hours rest in any 7-day period. The hours of rest can be divided into no more than 2 periods, one of which must be at least 6 hours long. You cannot work for more than 14 hours without taking rest. Unfortunately, most flag states use the calculation based on minimum hours of rest. This gives the ship owner more flexibility, as you can be required to work up to 91 hours in any 7-day period. In the event of an emergency where the safety of the ship and crew are in danger, or to give assistance to other ships or persons in distress at sea, the captain can suspend the work schedule until the problem is resolved. If normal working hours are disrupted by emergencies or unscheduled call-outs, you are entitled to an adequate compensatory rest period. Masters and all other drills must take place with a minimum disturbance to periods of rest. All ships have to display a table with shipboard working arrangements in the working language of the ship, and in English it must include: firstly, schedule of service at sea and service in port, maximum hours of work or minimum hours of rest required by law or by applicable collective bargaining agreement. Records must be kept of hours of work and hours of rest so that they can be checked to ensure compliance with their regulations. You must receive an endorsed copy of your hours of work and rest. There are additional guidelines designed to ensure protection of your seafarers. You shouldn't have to work for more than 8 hours a day and 40 hours per week. You should have enough time for meals, at least 1 hour for the main meal of the day and 15-minute breaks after every 2 hours. unless this interests with agreed training programs. So, Regulation 2.4 is announced to be entitlement to leave. It establishes that seafarers have adequate leave. You are entitled to paid annual leave and shore leave for the benefit of your health and well-being. Flag states have to determine minimum standards for annual leave, taking into account your special needs as a seafarer. The annual leave entitlement is calculated on the basis of 2.5 days for every calendar month of employment. Justified absence from work, such as sickness or attendance at the approved training course, cannot be considered annual leave. It is forbidden to deny or buy off your entitlement to paid annual leave. While you are on leave, all other contractual entitlements still apply. When you have signed off, the contract ends. The following shouldn't be counted as annual leave. They are public and customary holidays, time off for illness, injury, or maternity, temporary shore leave, compensatory leave. You should have the right to take annual leave in your home country. You shouldn't be required to take leave in a place where you have no substantial connection, unless it is with your agreement. If you do have to take your leave from a different place, then you should be entitled to free transportation at the shipowner's expense to your place of recruitment, as well as subsistence for the duration of the journey. The travel time shouldn't be deducted from your paid annual leave. When you take your leave, should be agreed between you and your employer. You should be able to take all your leave at once, but sometimes it may be divided into parts. As for the next regulation, which is 2.5, it is repatriation, which ensures that seafarers are able to return home. You have a right to be repatriated at no cost to yourself under the following circumstances. Your employment agreement expires while you are abroad. The ship owner terminates your contract. You terminate the contract for reasons that are justified. You are unable to carry out your duties under the agreement for reasons such as illness, injury, shipwreck, trading in a war zone, or if the shipowner fails to fulfill his or her legal obligations to you. The maximum period you can be expected to serve on board before being entitled to repatriation at the shipowner's expense is 12 months. Shipowners are not allowed to ask you for a contribution, nor can they make a deduction from your wages towards the cost of repatriation, unless you have seriously breached the terms of your employment agreement. If the shipowner fails to pay for your repatriation, the flag state must take over this responsibility. If for any reason the flag state fails to do this, contact your consulate or diplomatic mission. They should be able to arrange your repatriation and claim the costs back from the flag state, who in turn can claim against the shipowner. The port state should also help you to find a way home. All ships Flying flags of states that have signed the convention must carry on board and have available for seafarers a copy of the flag states' provisions on repatriation. The ship owner should pay for the following costs: passage to the place of repatriation, normally by air, accommodation and food for the duration of the journey, pay and allowance for the duration of the journey if specified by collective bargaining agreements or national laws, transportation of 30 kilograms of your luggage, medication treatment where necessary to make you fit for travel. You should have the right to choose your preferred place of repatriation from the following options. First of all, the place where you agreed to join the ship. Secondly, the place stated in a collective bargaining agreement. Then, your country of residence, or any other place agreed at the time of engagement. You should agree to whichever option you prefer at the time of engagement. If you are under 18, have served at least 4 months on your first foreign-going voyage, and find that you are not suited to a life at sea, you should be given the opportunity of repatriation at no expenses to yourself from the next suitable port of call. So, Regulation 2.6, Seafarers' compensation for the ship's loss or foundering. To ensure that seafarers are compensated when a ship is lost or has foundered. So, you are entitled to adequate compensation in case of injury, loss, or unemployment due to the ship's loss or foundering. These must be paid to you by the ship owner and shouldn't prevent you from asserting any other rights to claim you may have under relevant national law. For the period that you are unemployed, you should be paid the same amount as you would have received under the contract, but the total may be limited to 2 months' wages. So, Regulation 2.7, Manning Levels. It was implemented to ensure that seafarers work on board ships with sufficient personnel for the safe, efficient, and secure operation of the ship. You have a right to work on a safely and securely operated ship. There must be adequate crew on board in terms of number and qualifications to ensure the safety and security of the ship and all those on board under all operating conditions. The manning levels have to take into account the need to avoid excessive hours of work, ensure sufficient rest, and limit fatigue. They also have to take into account the requirement for seafarers working in catering and food services. Manning levels also have to take into account the nature and conditions of the voyage. If you think that your vessel is operating with insufficient manning, report it to your union or to ITF. There should be a compliance procedure in place to allow concerns to be raised with the flag state. The next regulation is 2.8, Career and Skill Development and Opportunities for Seafarers' Employment. It must promote career and skill development and employment opportunities for seafarers. Everyone concerned with the maritime industry has an interest in ensuring that the sector has a competent workforce. You should have the opportunity to strengthen your competencies, qualifications, and employment opportunities. So, today we have considered titles 2 and 3 of Maritime Labor Convention. Next lesson, we will consider Title 4. My best to you. Goodbye.